The broadcast is now starting. All attendees are in listen-only mode.
Okay, I'll stay.
Good afternoon. Thank you for joining us for today's webinar focusing on FINRA. My name is Allison Owen, and I am Pacific Stock Transfer's Director of SEC Filing Services and Special Projects. Pacific Stock Transfer Company is an independent stock transfer agent headquartered in Las Vegas with over 30 years of experience in the securities industry. Registered with the Securities and Exchange Commission and a member of the Securities Transfer Association, Inc., Pacific Stock Transfer is dedicated to serving the needs of domestic and international companies, both public and non-public. Before we get started, I wanted to give some information on how today's webinar will work. We will shortly kick off the presentation to be followed by a Q&A session. Please feel free to use the chat function on your webinar toolbar to submit questions at any time throughout the presentation. After the presentation, we will answer as many of the questions as we're able. Today's webinar is sponsored and presented by Andersen PC and Ofsink LLC. We're joined by Scott Andersen and Svetlana Rovinskaya, respectively. Scott, I'll go ahead and let you kick things off.
Okay, great. Why don't we move to slide number 2. Good morning, everybody. My name is Scott Andersen. I'm principal at the law firm of Andersen PC. I recently was an employee at FINRA, where my most recent job, I was Deputy Chief Counsel in the West Region, based in Los Angeles. I left FINRA on February 6th of this year. I had been with FINRA from its inception in 2007, so I know a lot about it. I was based at headquarters in New York before I moved out to Los Angeles about 3 years ago. Before working at FINRA, I was also director in the enforcement department at the New York Stock Exchange, and then before that I worked for the New York Attorney General's office, where I worked under Elliot Spitzer. I wanted to give Svetlana an opportunity to introduce herself as well.
Svetlana Rovinskaya. Oh, sorry about that. Hi, good afternoon. My name is Svetlana Rovinskaya, and I'm an attorney here at Ofsink LLC. Prior to coming here, I was an examiner at the New Jersey Bureau of Securities, which is the New Jersey State Securities Regulator, for about 2 years, where we regulated mostly small to mid-sized investment advisors and broker-dealers.
Okay, great. Thank you for that. Why don't we move on to the next slide? So today we're going to hope to address some questions and hopefully answer some of your questions with respect to when will you hear from an issuer, and such issues as why is it so difficult presently to have small cap securities deposited at small broker dealers. I understand that the audience is primarily consists of issuers, representatives of issuers, and I hope that today's presentation will be beneficial to you. As I had mentioned earlier, I left FINRA on February 6th, and I had been there since the time that FINRA was formed in 2007. FINRA, of course, was formerly known as the NASD, which became FINRA when the NASD purchased New York Stock Exchange regulation. I will begin by briefly telling you what FINRA does. Let's go to the next slide. So FINRA is the SRO, self-regulatory organization responsible for regulation of the securities industry. Generally, what FINRA is responsible for is to regulate all the broker-dealers and their representatives in the United States. Next slide. Okay, FINRA basically regulates the brokerage industry in 5 different ways. The first, and one of the most important, is they work to deter misconduct by enforcing the rules. By rules, FINRA writes disciplinary rules and enforces its rules and regulations for every single brokerage firm in the United States. And it also enforces the federal securities laws, as well as municipal securities rulemaking rules. All brokers in the United States must be licensed and registered by FINRA and are subject to FINRA inquiries and investigations. Question may come to your mind, well, how does FINRA go about enforcing its rules? Every day there's literally hundreds of FINRA examiners in the field, on-site at brokerage firms, examining the brokerage firms to determine their compliance with FINRA rules and the federal securities laws. These examinations could be routine examinations, which are generally done on an annual basis of each registered broker-dealer, or they could be cause examinations, which means that examiners are on site to review specific investor complaints or suspicious activity that FINRA has become aware of. FINRA has the ability to do unannounced on-site examinations as well as announced on-site examinations. They also generally review broker advertisements, websites, sales brochures, just to make sure that they comply with the rules and make sure that the presentations are being made in a fair and balanced manner. The second item that FINRA does to regulate its members is it takes disciplinary actions against those who break the rules. This is essentially what I did. I was an employee at the FINRA Enforcement Department for several years. And upon any notification that there may be a potential violation of FINRA rules or the federal securities laws, FINRA opens up an investigation. Generally, it gets assigned to an enforcement attorney like myself who conducts an investigation. That investigation could include written request documents because FINRA, as it's not a governmental agency, it issues what's called Rule 8210 request, which members are required to respond to. In order to continue their membership with FINRA, they must comply with FINRA Rule 8210 request. And those requests could be in the form of requiring written responses to questions contained in the request, producing documents, whether it's maintained in paper form or electronically, or coming down and appearing at a testimony before a FINRA examiner or FINRA attorney. Just to give you an idea, last year FINRA brought just under 1,400 disciplinary actions against registered individuals and firms. I think its fines totaled about $134 million, and it had a restitution of approximately $32 million. FINRA is a self-regulatory organization. It is not a government agency. It does not have criminal powers, but it does have regulatory powers in order to discipline its members. The most severe sanction that FINRA possesses is it could bar a broker from the securities industry, or it could expel a brokerage firm from the securities industry for failure to comply with federal securities laws and FINRA rules. Okay, the third item, how FINRA regulates its members, and this one I want to spend a little bit more time on today, is FINRA detects and prevents wrongdoing in the U.S. market. So basically, FINRA watches the nearly, I think it's 6 billion shares that are traded on U.S. listed equity markets every day using technology to try to identify potential abuses. You know, two of the things that FINRA really focuses on is trying to detect whether there's any patterns of insider trading, or two, whether there's any manipulation in the securities market. Presently, a big concern in the regulatory arena is what is occurring in the small cap market. FINRA and other regulators have seen a pattern of where there are spikes in the volume and the trading price of low-cap securities at the same time that there is ongoing internet marketing of the securities that have raised concerns that this could be pump and dump situations, that FINRA takes actions to further investigate. In 2014, in addition to the enforcement actions that FINRA has brought, it had referred 700 fraud and insider trading actions or potential actions to the Securities and Exchange Commission and other agencies. Other agencies would include, for example, state regulatory authorities. Many of these referrals, as I had referred to a moment ago, occur when FINRA sees spikes in trading activities or other anomalies which raise concerns that there could be stock manipulation. And because FINRA traditionally is the regulator of the broker-dealer and not the issuer, FINRA will generally refer any concerns that it has concerning issuer conduct to the Securities and Exchange Commission. Because FINRA is concerned about these type of activities, FINRA has come down with some significant regulatory actions against broker-dealers. Again, FINRA really regulates the broker-dealers. It doesn't regulate the issuers, but because of its concerns with a potential sale of unregistered securities in violation of Section 5 of the 1933 Act, or because of concerns about potential manipulation of small cap securities, FINRA has brought actions against its members, primarily charging a violation of Section 5 of the 1933 Act for essentially permitting unregistered sales to occur without doing ample due diligence to make sure that the securities are freely tradable or fall under an exemption to the 33 Act. One example of a case that was announced in January of this year was a case against Edward Jones, which was censured by FINRA and fined $100,000 on a theory that Edward Jones failed to develop and implement adequate AML procedures for the review of deposit and liquidations of third-party stock certificates and customer accounts. Generally, when FINRA will bring an action against the broker-dealer, it will structure that action as a failure for the broker-dealer to have proper supervisory procedures and systems in place to supervise its business, or as indicated in this case, failure to have adequate supervisory AML procedures to make sure that it is supervising its business. Last year, a very notable case came out by FINRA against Brown Brothers Harriman, where Brown Brothers was actually fined $8 million for, again, a substantial anti-money laundering compliance failures. And I'm going through this because I'm just trying to kind of paint the picture for you as kind of what the broker-dealer membership is seeing that the regulator, the actions that the regulator is taking. And I think these actions may have resulted perhaps in some more difficulty in filing small cap stocks or selling or liquidating small cap stocks through a broker-dealer than has been the case in the past. In the case against Brown Brothers Harriman, the firm was fined $8 million again for anti-money laundering compliance failures, including, among other violations, the failure to have an adequate anti-money laundering program in place to monitor and detect suspicious penny stock transactions. Brown Brothers Harriman failed to sufficiently investigate potentially suspicious penny stock activity brought to the firm's attention, but it did not fulfill its suspicious activity report, or SAR, filing requirements. In addition, it did not have an adequate supervisory system to prevent the distribution of unregistered securities. In its comments in the press release that was issued last year, FINRA had stated that penny stock transactions pose heightened risk because low-price securities may be manipulated by fraudsters. That FINRA found from January 1st, 2009 through June of 2013 that Brown Brothers Harriman executed transactions or delivered securities involving at least 6 billion shares of penny stocks, many on behalf of undisclosed customers of foreign banks in known bank secrecy havens. Braun Brothers Harriman executed these transactions despite the fact that it was unable to obtain information that was essential to verify that whether the stocks were free traded. In many instances, Braun Brothers Harriman lacked such basic information as the identity of the stock owner's beneficial owner, the circumstances in which the stock was obtained, and the seller's relationship to the issuer. Okay, and we're going to return to this in a few minutes to talk a little bit about what type of actions FINRA takes when it detects suspicious activity in the trading of some of these small cap stocks. But I just wanted to finish up the slide here and talk about the other two manners in which how FINRA regulates its members. The next item is that FINRA educates and informs investors. There's various tools on FINRA's website which the public could access, which are beneficial. One is Broker Check, which is a tool which you could access to look up the disciplinary history of your broker. Another one is Trace, which includes bond market activity that is recorded from FINRA's trade reporting and compliance engine. The last item that FINRA does to regulate its members is it provides arbitration services so that any disputes between investors and FINRA members can occur before FINRA arbitration. Okay, let's go to the next slide. Thank you. So, as we had discussed, FINRA's essential mission is to regulate broker-dealers and brokers, not issuers, not investment advisors, not transfer agents. But part of our discussion today is why then do issuers at various times have interactions with FINRA. We're going to talk a little bit about that in the context of Rule 6490, and we'll continue the discussion about these types of interactions that occur when we're dealing with small cap securities. Let's go to the next slide. So presently, there's a heightened trend by regulators to look closely at the trading patterns in small cap securities. FINRA, the SEC, and the Federal Bureau of Investigation all have noted a heightened concern and issue of potential stock manipulation occurring in small cap securities. I had mentioned earlier that FINRA had referred 700 different cases to the SEC last year, and a lot of these cases stem directly from issues where FINRA believes there's suspicious trading activities and there may be some unlawful conduct. Let's go to the next slide. After FINRA sees anomalies in the market, like a sharp increase in volume or the stock price, FINRA generally investigates. FINRA investigates in many different reasons, many different ways. FINRA has jurisdiction over all broker-dealers, so it could issue Rule 8210 requests to get whatever information it needs to conduct its investigation from its members or their employees, and that includes taking their testimony. But FINRA will even reach out to entities which does not have regulatory jurisdiction over to ask questions about and to get information from. Because FINRA doesn't have jurisdiction over these entities, this generally will be done on a voluntary basis if these parties are willing to cooperate, and specifically I'm talking about transfer agents and issuers. FINRA will, if it deems it's appropriate to further its investigation, reach out, contact an issuer, request to interview the CEO of an issuer or other officer of the entity, and ask questions about this trading of the stock, whether there's any reason why the stock should be spiking in volume or price, whether the issuer has paid any stock promoters to promote the stock over the internet. We'll inquire into recent press releases issued by the issuer to probe them to determine whether the press releases contain any exaggerated information or whether the information contained in the release was well-founded, and whether there are potentially any statements contained in the press release that may not be truthful. Okay, just bear with me for a second. I wanted to, we talked a little bit earlier about actions that FINRA has brought against its own broker-dealers, and that FINRA doesn't have jurisdiction, but it sees issues that raise a concern for it in the market, that it will make a referral to the SEC. I don't know whether this particular matter resulted from a FINRA referral, but I thought it would be interesting for people on this call to hear about this. On April 21st, just a few days ago, the United States Securities and Exchange Commission announced the temporary suspension of trading in the securities of Forcefield Energy, Inc. That's FNRG. And basically what the SEC did is it used its emergency powers to halt the trading in that security for a period of 10 days. And when doing so, the Securities and Exchange Commission issued an order describing that it froze trading in FNRG due to concerns that it had about the adequacy and the accuracy of information available to investors concerning the funding of recent articles and promotions touting FNRG. The SEC noted that there are questions that have arisen concerning this stock, whether this stock was involved in a potential manipulation. Later that day, a class action was filed in the United States District Court for the Southern District of New York, where the individual plaintiff's lawyer who filed the action and issued a press release to try to identify other potential investors who purchased this particular stock and would be seeking representation in the class action. The complaint alleged that the company failed to disclose that members of its management team have substantial connections to public companies that have been scrutinized for fraudulent and illegal activities. The class action lawsuit also alleged that the alleged defendants, which was the issuer and the principals of the issuer, stated or failed to disclose that articles issued by independent authors who touted the issuer on the internet were in fact paid promoters hired by the company, and that the company itself reviewed these so-called independent articles before publication, and that the members of the management team, again, it's alleged in the complaint, have a history of working with companies that were alleged to be engaged in fraudulent activities. A few days before the SEC announced the freeze of this stock, and before the class action lawsuit was announced, there is an article that appeared, I believe, in Bloomberg on April 20th, which announced the arrest of the chairman of Forcefield Energy, Inc. His name is Richard St. Julian, who stepped down from his position after he was charged with securities fraud by federal prosecutors in Brooklyn, New York. He was accused, according to the article, of scheming from August 2012 to present to manipulate the stock of Forcefield Energy by paying stock promoters, broker-dealers, and others to purchase or tout the stock over the internet. Mr. Julian, who was 46, was arrested while boarding a plane to fly to Costa Rica. Okay. So the point that I wanted to make here is that FINRA has focused on bringing and focused its regulatory attention to investigating these potential stock manipulations and small cap issues. In its 2015 examination priority letter, just to explain, every year FINRA issues a letter which it describes what its priorities are. And in 2015, in January of 2015, FINRA identified, falling under kind of its AML concerns, identified once again that FINRA is very concerned, and one of its examination priorities is the due diligence that its member firms are conducting when accepting micro-cap securities for stock liquidations in particular, and that there are certain expectations of that thorough due diligence process will be made before those stock liquidations occur to ensure, number one, that its members are not engaged in the unregistered sale of securities in violation of Section 533 Act, or number two, aiding or facilitating the unlawful sale of securities by others. I think that itself is just verification, written verification, that this is a hot area for regulators now. I think if you go back and if you look at the SEC actions, you will see that there's been an uptick in the actions taken recently with respect to this specific area of regulatory concern. And three, with respect to criminal authorities, I don't think we need to say much more than to point to the arrest that I alluded to by the Brooklyn U.S. Attorney's Office that occurred just a week ago. So why don't we proceed next to slide number 9. This next slide talks about another basis in which FINRA may be reaching out and contacting issuers. And this will occur pursuant to Rule 6490, which is a FINRA rule which mandates that issuers provide certain information to FINRA. And I'm going to turn this over to Svetlana in a moment to let her talk a little bit more about this. But let's go to slide number 10. Slide number 10 just asks again, FINRA is the regulator of broker-dealers and its members. So why is FINRA regulating something that really has to do with issuers? And the answer lies in SEC Rule 10b-17. Under SEC Rule 10b-17, the SEC specifically designated FINRA as the agent that will receive notice in accordance with Rule 6490, and that's the basis in which FINRA has the authority to proceed and make these requests to issuers. Okay, so with that, I'm going to turn it over to Svetlana. Thank you very much.
Hi, good afternoon, everyone. So like Scott was saying, FINRA doesn't technically, regulate issuers. So how is it that they're able to put issuers through this lengthy process of complying with Rule 6490? So like Scott said, what the SEC did in 2010 was give FINRA this right, and FINRA Rule 6490 basically codifies the Exchange Act Rule 10b-7. So that rule basically makes it a manipulative or deceptive device if you don't make this filing and provide the necessary information to FINRA. So that rule says that any issuer that has securities traded on the over-the-counter market, so like OTCQB, OTC Pink, OTCQX, all those issuers have to give FINRA notice within 10 days before either the record date or the effective date of certain corporate actions. So if a corporation or an issuer is going to take one of these actions, they have to go through this process. They have to file an electronic form, pay applicable and non-refundable fees, provide a ton of information, and possibly follow-up information as well. And then FINRA, in their discretion, can either conduct detailed reviews of the submission on a case-by-case basis and then decide to approve or reject the request. So that's kind of the overall process. So now that we know that, we could take a look at the next slide to see what types of corporate actions trigger the requirements of 6490. So these could be dividends or other distributions in cash or in kind, but it does not include ordinary interest payments on a debt security. It does include stock split, reverse stock split, name change, trading symbol, mergers, acquisitions, dissolution, other controlled transactions, bankruptcy, and liquidation. So if an issuer that has securities that trade on the OTC markets wants to take one of these corporate actions, they have to comply with Rule 6490. And so what does that mean? So if you take a look at the next slide, what it means is that the issuer has to file the Issuer Company Related Action Notification Form. This is an online form that gets filed, and filling out the actual form is probably the easiest part of the process. The actual form, like I said, it's just an online form, and you put in relevant information depending on your corporate action. So, for example, if you're doing a stock split, you want to say the number of shares outstanding before and after the corporate action. And basically, the form will prompt you to provide the information you need based on the corporate action that you select. Also, when you submit the form, it has to be, like we said, 10 days before the record or effective date. And you have to pay the fees, which are non-refundable, and attach the supporting documentation. So, like I said, the actual form itself is the easy part. The hard part is the supporting documentation, which, depending on the corporate action, can consist of different things. It could be board resolutions, notarized officer certificates, a copy of your articles of incorporation and every single amendment made since then, resignations of officers, just a plethora of different information that you might have to attach depending on your corporate action. So, the most important thing to remember when putting the form and the attachments from the form together is that it's a multifaceted process, and it's super important to plan ahead and make sure that you have all the necessary information you need for the form and the documents for the form. It's a really good idea to outline a timetable with tasks and due dates so you can have everything ready and keep easy track of everything. So when you submit the form, it's not only you, the issuer, that has to submit the information in the form, the required attachments, and the fees. You also have to coordinate with some third parties. Some corporate actions, like a reverse stock split, involves you having to go to the CUSIP Bureau to get a new CUSIP number. So you have to be mindful of that and make sure that you coordinate with CUSIP in advance so you have the number to submit with your application. So similar to that is you have to coordinate with the transfer agent in advance, because the transfer agent has to submit something called the transfer agent verification form at the same time that the issuer submits their company-related notification form. So, like I said, the most important takeaway is that it's an involved process with many moving parts, and the best way to handle it is to identify the corporate action that you want to take, figure out what information you need to include in the form, what attachments you need to include in the form, and what third parties you need to coordinate with to make submissions. And, of course, one of the most important things is paying the fees. So if you take a look at the next slide, it has a little summary of all of the fees. And the main takeaway is that as long as you file on time, you will pay a reasonable fee. However, if you're late, even a little bit late, as you can see from the chart, the fees increase substantially. Another thing to keep in mind is that you can do multiple corporate actions on one form. But if you do that, you have to pay the multiple fees associated with each action. So let's say you're doing a voluntary symbol request and name change, you would have to pay, both of those fees. And we'll talk about this a little bit more in a few minutes, but if you want to file an appeal if FINRA rejects your action, again, you have to pay a non-refundable fee. So now we've submitted our application and we've paid our unrefundable fees, and we could take a look at the next slide, which will talk about the review process and how it works. So you would, ideally want to reserve at least a month for FINRA to process the application, but in practice, it could take 2 to 3 weeks. However, it can also be an extremely lengthy review process, and you can't really ever estimate with certainty how long it will take. Once you submit everything, FINRA assigns you a specialist to review your application. That's your point person at FINRA that you're dealing with. You could check the status of the application with them. They ask follow-up questions to you. So that's the person you have to coordinate with. Now, something really important to keep in mind is any additional documentation that FINRA asks you for, you have to provide it within 90 business days or 90 calendar days. If you do not do this, FINRA is going to consider your application lapsed and close it. So all the fees and all the effort and everything you put into preparing it will be wasted. So you have to make sure to reply to them within 90 days of their request. So now that FINRA has all your information, they're going to review it. And the rule itself, 6490, outlines 5 specific things that they look for. And if any one of these is present, FINRA can either choose to do an extremely in-depth review of your application or just reject your application. So what are these factors? And it's, you know, both a good and bad thing because it's 5 specifically enumerated factors that they look at, but some of the factors are very broad. So, you know, if you provide them with an accurate supporting documentation, if the issuer is not current in its reporting obligations, if a person associated with the corporate action is involved either with an ongoing or even a past adjudicated or settled regulatory action, investigation, civil or criminal action that are related to securities fraud. Even if it's in the past, that could still be a factor that could trigger either the in-depth review or the rejection. Other factors are more geared to protect public investors. So if FINRA has actual knowledge or gets information from somebody else, like a regulator, that a person connected to the corporate action may potentially be even involved in securities fraud, they can reject the action. And the 5th factor is if there's significant uncertainty in the settlement and clearance of the security. So everything is geared to protecting the markets and protecting investors. So they'll look for those 5 factors. You know, and at some point while you're going through the corporate action with FINRA, you will get contacted by the DTC to possibly provide a legal opinion. If it's a reverse stock split, for example, it would be with regard to the free trading status of any free trading shares and things like that. So once FINRA is done reviewing your application and asking you follow-up questions, if you take a look at the next slide, FINRA then gets to decide whether they want to approve or deny the action. So if they approve the action, they announce it on their website in something called a daily list, and you're done. If FINRA denies the action, they'll provide you a notice outlining all the deficiencies and why they're denying the action. And it's up to the issuer whether they want to accept this denial or they want to file a written appeal in 7 days. The written appeal, like we talked about before, has to be accompanied with a non-refundable fee and an explanation of why the issuer disagrees with every single deficiency and supporting documentation to address it. After you file an appeal, a 3-member subcommittee at FINRA will review it. That committee meets once a month, and once they review it, they'll make a decision within 3 business days. Whatever decision they make is final. So whether you don't appeal your deficiency denial or you do and you get rejected or approved, those are final determination by FINRAs. So basically, another important thing to talk about, and maybe one of the most important things, is that, you know, the punishments for failure to comply with 6490. Noncompliance with this, with the Exchange Rule 10b-7 is an ongoing concern for FINRA. It's one of the reasons that Rule 6490 came to fruition, and the purpose of the rule was basically to make it so that companies that trade on the OTC were subject to some kind of review for these corporate actions so they could protect investors and protect the market. So because Rule 10b-17 is a fraud rule, if you violate this, you're potentially violating an anti-fraud rule of the securities laws, which is very serious. And the possible sanctions are substantial, and they don't only apply to issuers, they can also apply to transfer agents who knowingly aid and abet violations of this rule. And, like Scott said, FINRA, when they have this actual knowledge, they're going to provide a list and refer the non-complying issuers to the SEC staff. So it's very important to comply with the rule just because the punishments are, extremely substantial. But overall, the main thing to keep in mind is that you want to be prepared and get all your documentation in advance. If you have to, file this form with FINRA, you want to coordinate with third parties, and you want to have all the moving parts ready so you get everything to FINRA as early as possible to make their review as easy as possible and their follow-up questions as minimal as possible. And so that's about it for that portion, and if anyone has any questions.
Thanks, Svetlana and Scott. We do have just a couple of questions, if you don't mind. The first is, what are either of you seeing as problems on the horizon in dealing with FINRA?
Yeah, I'll take that. I mean, historically, looking at FINRA the last few years, what I've observed, in addition to kind of the concern about the reoccurrence of the pump and dump, a problem that was very similar to that back in the 1990s with Stratton Oakmont and Jordan Belfort, but now being done on the internet. In addition to that, there's always FINRA concerns specifically over getting broker-dealers, getting them up to speed with respect to having adequate AML compliance procedures. That's a very important goal. The other one is in sales to retail investors, making sure that sales of sophisticated products such as exchange-traded funds, inverse leverage exchange-traded funds, or other sophisticated products, that number one, that the broker who is offering or recommending the product understands the product, how the product works, and that the product is suitable for the investor to whom the investment is being offered. I think those are concerns that we've dealt with in the past, and it will be concerns that FINRA continues to address going forward.
Great, thanks, Scott. Do you have anything to add?
Oh, sure, yeah. I just wanted to add that, one of the main trends is now that FINRA is reviewing the, small micro-cap companies. They are doing extremely detailed reviews, and it's a process that could take a while and that you do have to be patient for because they review things very thoroughly now. And the trend we're seeing is that, everything's in the internet age now. They even conduct Google searches. They do their own independent research, and every single thing they find, they will question you about. You'll have to provide documents like subscription agreements, convertible notes, maybe from, several years ago. So just something to keep in mind is that they are conducting very detailed and thorough reviews, and that the process might, take longer than anticipated, and to just be patient and as responsive and open with them as possible.
Great, thanks, Svetlana. We have a couple of more sort of specific questions, I guess. The first is, does Rule 6490 apply to the foreign private issuer?
So it applies basically to any company that has like OTC securities traded. So it doesn't matter where you're from as long as you have OTC securities trading.
Okay. And then the last question that we've got is whether a company would need to go through FINRA to migrate their jurisdiction from one state to another.
Can you just repeat the question?
Yeah.
Sure. So the question is in relation to a company migrating their jurisdiction from one state to another, and whether or not the issuer would need to work with FINRA for that action.
Oh, yes. If it's a merger, then that is one of the corporate actions that trigger the rule.
Okay, great.
Yeah, typically it's a redomicile merger, and then that does necessitate the filing.
Okay, and then we have one last question, if you just give me 1 second. Okay, so if FINRA rejects a 6490 application, does FINRA expect the issuer to reverse the corporate action on a state level? And then what is the issuer supposed to say to its stockholders that have approved the corporate action?
Well, if FINRA denies the corporate action and you can appeal, and while you're appealing, FINRA stays the action until the decision is made. However, if you don't appeal, FINRA's determination is final, and there's not much that can be done about it, because if they deny the action, then it can't go forward. Or,
okay.
It can't go forward in a legal and compliant way, and it would be a fraud on the market, so you could possibly be subject to the securities violations that we talked about if you would proceed after they would deny that.
Sure. Okay, and then it is becoming increasingly difficult for subscribers to deposit shares with brokers. What do you suggest investors do to get their certificates deposited, and do you see it getting easier down the road?
Right now it's, because of all the regulatory attention to this area, a lot of the broker-dealers are a little bit gun-shy. I know that there's been some that have exited the business and are not willing to do this type of business. As Svetlana had mentioned a moment ago, the due diligence requirements are pretty extensive for the broker-dealers. So to go through, make sure that they're not participating in unregistered offering of securities. Unfortunately, I don't know what the solution to this is. There are regulatory actions that are occurring by multiple regulators on an ongoing basis, and once the fraudulent activity or the alleged fraudulent activity is deterred, I think things will resume and go back to normal until there's another time in the future where there's another uptick in the type of manipulative activity that's being observed now. And at that point, or at the point that the activity level goes down, hopefully that it will be easier for deposits to be made.
Okay, and we've got time for just one last question. Does FINRA, in your experience, have a problem with shareholders that hire marketers to bring awareness to issuers as long as it's disclosed?
Well, FINRA regulates its members, and if its members put out any type of marketing materials, those marketing materials have to be fair and balanced and disclose all material facts. While FINRA doesn't regulate issuers, I think I would strongly advise the issuers to do the same, to make sure that anything that they're putting out there is presented fairly, meaning that the communication emphasizes an investment in the issuer fairly, meaning it indicates that there's risk with the investment as well as any positive aspects. The other thing is that obviously if there's any paid promoter, that should be indicated on any communication that is being issued by a paid promoter. There should be an indication there that the person is being paid for putting out the information that they are talking about. I think the general view is everybody views more communication about the potential investments to be a positive thing. Now we have the enactment of a general solicitation in certain types of securities offerings, which is pretty revolutionary in the marketplace. But again, we just want to make sure that the communications, whether they're in the form of an advertisement or otherwise, are fair and balanced and appropriately identify all material facts related to the investment.
Great. Okay, so that's all of our questions for today. Everybody, thank you again so much for tuning in. A big thank you to Scott Andersen and Svetlana Rovinskaya If you have any further questions, please feel free to shoot them to me, and I will get them to the respective people, or Scott and Svetlana's contact information was up at the beginning and the end of the presentation. Thanks, everybody.